Hi there, my name is Marla Neufeld, and welcome to the Surrogacy Space. Today, we're going to talk about who can work with a surrogate in Florida. So, as I've mentioned before, every state has different laws regarding surrogacy. And in Florida, really anybody that wants to work with a surrogate can do so under the laws of Florida. You can be a single parent, you can be a married couple, you can be an unmarried couple, you can work with an embryo created from a donor egg, a donor sperm, or you can even use a donated embryo in Florida when working with a surrogate. So it's really great that Florida is inclusive to anybody that needs the assistance of a gestational surrogate to build their family. That being said, the law that you proceed under in Florida does differ depending on the facts of the case. So, Florida surrogacy statute is for married couples using at least one of their genetics in the creation of their embryo. If you're single, not married, or using a donated embryo for your embryo transfer, you can still legally pursue surrogacy in Florida. It's handled under a subsection of our adoption statute, and it's called a pre planned adoption. At the end of the day, whoever is considering working with a surrogate in Florida, you still follow many of the same exact steps. So it's important that you enter into an enforceable surrogacy contract between the intended parent or the intended parents and the surrogate prior to starting any kind of fertility medication. And once that contract is executed, it's also important to understand that there will be a court process involved to place the intended parent or the intended parents on the birth certificate. In Florida, the court order that you receive for purposes of the issuance of the birth certificate is issued after the baby's born, right after the baby's born. So we're a post-birth state. Many times, your attorney may recommend to also get a pre-birth order in Florida. The pre-birth order would be for purposes of the hospital, so they know who everybody is and there won't be any difficulties with access and decision-making authority at the delivery. But for purposes of vital records issuing a birth certificate, they will require the post-birth court order in Florida. One more thing that is unique to Florida is we have a medical need requirement in our statute. So in order to proceed with surrogacy in Florida, there must be a determination by the doctor that either the couple cannot gestate to term or pregnancy would cause a risk to the fetus or the intended mother. So in Florida, it's important to speak with your attorney at the beginning of the process to make sure that you do qualify for the legal ability to pursue surrogacy in Florida based upon that medical need. If you have any questions regarding the surrogacy laws in Florida, please don't hesitate to reach out. But we are a surrogacy-friendly state where anyone can come to Florida and proceed with a surrogate. And my general rule of thumb for purposes of being able to utilize Florida law for the contract and the court proceedings is as long as the birth is occurring in Florida, then you'll be good to go on proceeding with Florida law. And there may be other limited circumstances to allow Florida law as well based upon certain connections to Florida. So feel free to reach out. Thank you for listening to the Surrogacy Space, and let me know if you have any questions regarding surrogacy.